On the record in Monbury versus Lancaster, this is file number 2520012. If I could have counsel put your appearances in.
Record, Your Honor, Metro on behalf of the people.
Good afternoon, Your Honor. Larry Brown on behalf of Mr. Lancaster.
Okay, I believe we're set for sentencing on a PPO violation. Mr. Lancaster pled guilty to that violation back in March. And so we set this, I believe, for a separate date in case the victim wanted to address the court. Mr. Rolla, do you have any? Do you have a petition that wishes to address the court?
They're here.
Okay. Ma'am, if you just come right up to that podium there, please. And can you tell me your name?
Monbury.
And you're the petitioner, you obtained the personal protection order?
Okay.
Okay, what is it that you would like to say today?
I just want this to be over. Mr. Lancaster to leave me alone. This has been a nightmare for a couple years now. He's got to stop. He's repeatedly broken this order. Right up to the last time being in my backyard, sending me messages, letting me know he was back there. When the police came, we ran, they never caught up. I have my grandson, my daughter, it's got to stop. It's got to stop. Thank you.
No, I think that was the only victim.
Anything that you want to say for allocation?
Judge, this is a PPO violation. Obviously, we have PPOs for a reason. I think the court, by sentencing, needs to deliver a message to Mr. Lancaster that he actually has to obey the court's orders, and anything other than that will effectively send the wrong message. Thank you, Your Honor.
Thank you, Mr. Brown.
Thank you, Your Honor. I do agree. We do have PPOs for a reason. This court is well aware, however, that anytime a PPO is issued, it is not uncommon for the victim of a PPO to contact the person that they have a PPO against. As far as I know, I'm sorry, I don't know the last name here, but Kelly did advise that she had talked to my client and messaged back and forth and had several conversations with him. It is his assertion, I can't prove it, but it's his assertion that she invited him over. He went over there for a couple of hours. They had a conversation. He left. There was no violence. There was no issues or anything like that occurred. No new charges. He's been out on bond. He's had no new charges on bond. He has no prior assaultive history at all. And I don't know the underlying facts of the PPO. I wasn't here for any of those hearings. He is currently in the work camp. He's on probation as well with the drug court in the work camp program. He's passing all of his drug tests. Again, Your Honor, I don't know what happened, and while I'm not trying to minimize the PPO, as far as any violation in this particular case, it very well may be that this was a mutual thing that happened. While she did mention in the report that I received that she was afraid to report this because she was afraid she would get in trouble for communicating with him. So there was obviously some mutual communication going on. I would ask all of the court to take all those things into consideration in fashioning the sentence here, especially his lack of any kind of violent history and the fact that he is currently on probation in the work camp program as well.
Thank you. Anything that you wanted to say, Mr. Lancaster? Okay. I reviewed the police report that was filed in this case, and it does contain some statements both by Ms. Monbury and Mr. Lancaster regarding the circumstance. The court notes that this personal protection order was entered at the end of February of 2025. This is the first alleged violation. Based on the police report, it does not appear that it involved any assaultive behavior. Typically, in those circumstances, Mr. Lancaster, the court can punish violations of an order in various ways. One of those ways is incarceration and jail time. Another way that the court can punish it is through financial obligations and fines. Typically, for a first violation, the court imposes a fine as opposed to jail time, in the hopes that that's going to get the message through to the person that this is an order of the court that cannot be violated. And there aren't any aggravating circumstances here that require the court to change from my general policy. I will indicate, I don't know whether she contacted you or not, but I will indicate that you cannot have contact with her under any circumstances, regardless of whether she contacts you first or not. That is not a reason that you continue to have contact with her, you're going to be arrested. I can also assure you that if there are any violations, whether they're assaultive or not, whether they involve in-person contact or text messages, that the court will impose jail time for a second violation. So you should be abundantly clear that there is no reason to contact Ms. Lounsbury directly. There's no reason to contact her by text. The police report does indicate that you were texting her multiple times even after the PPO was entered. And to the extent that you do that again, you will spend some time in the Otsego County Jail. That may have an effect on your drug court program too. So I think it's in your best interest to avoid all contact with Ms. Lounsbury any way whatsoever. That being said, the court is going to impose a $100 fine. You need to go downstairs after this hearing to the clerk's office and make arrangements to pay that fine today. And again, you should not have any further contact with Ms. Lounsbury in any way. Do you have any questions about that?
No, I do not.
I'm going to ask that you remain here in the courtroom for a few minutes to allow Ms. Lounsbury and her parties to leave the courtroom so there isn't any contact in the hallway. And then after that, I'll have you go downstairs as I indicated. Mr. Rolla, anything else you'd like to address on this file today?
Not this one, thank you, Mr.
Brown,
Excuse me, no, Your Honor, thank you.
you can go ahead and have a seat in the first row there, Mr. Lancaster.
Thank you, Your Honor.
Yes.
Your Honor, I believe that is the only matter I have.
Okay, thank you.
I just did have a 1:30. I did not receive, I did a stipulation order, Mr. Rolla. I didn't receive it, but I was informed that the court was going to sign it.
Yes, and haven't been able to do that yet, but I am going to sign that. And so yeah, the 1:30 is not an issue.
Okay, thank you, Judge.
Yes, sir.
So what, do you need a chance to speak with Mr. Davis before sentencing?
No, I've already spoken.
So we'll just take a short break once Mr. Davis is present. Okay, we're on the record in People versus Brian Davis, file number 256803. The record should reflect Mr. Davis is present here in the courtroom, but I can have counsel for your appearances on it.
Thank you. For the record, I call the people.
And Jonathan Baber on behalf of Mr. Davis.
Okay, and just so counsel are aware, I did receive a letter from Mr. Davis that you wrote. I had a chance to read that before hearing today. And then Mr. Baber, I did receive that evaluation that was prepared. I also had a chance to review that prior to the hearing today.
Thank you.
Mr. Davis, did you have an opportunity to go through the pre-sentence report and talk with Mr. Baber about that?
Yes.
And Mr. Baber, are there any additions, deletions, or corrections to that report?
Just a typographical error. It's technically page 6 of the PDF labeled as page 2 under description of offense narrative. The last paragraph there, it says that he stole the semi-truck on 1/18/24. That should be 11/18/24.
That's correct, Sean.
Okay, to make that change, any other corrections?
Nothing from the defense judge.
Are there any challenges to the scoring of the guidelines?
No challenges to the scoring of the guidelines.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, we do not.
Anything on behalf of the people for elocution?
Judge, briefly, the court obviously has seen the defendant's prior criminal history. He's been a lifelong car thief. I guess this is the 13th larceny type offense, although a number of them are not accountable for sentencing guideline purposes because of the 10-year gap. It's a situation where the defendant had been on parole. He was either still on or just off parole when this offense occurred. Quite frankly, not a lot is going to make any circumstance is going to do anything to stop this defendant from continuing his behavior except incarceration. Thank you, Judge.
Thank you, Mr. Baber.
Thank you, Your Honor. I appreciate the opportunity to address this court. Appreciate this court reading the psychological evaluation submitted with the PSI. I just fundamentally disagree with the prosecutor's position that nothing can be done to correct this behavior. First time in all of his convictions, what we have here is a mental health diagnosis that's never taken place before. Unfortunately, for my client, first met my client, within minutes, he was in tears begging me for help for what's going on. The situation is this: my client steals semi-trucks and he drives them until he's stopped and then he gets arrested, and that's it. He's not doing this for financial gain. He's not doing this to sell these parts. There's something clearly that's going on mentally here that's probably an explanation of his behavior. And what I did was I went out and I just didn't get anybody who just sided with the defense. I got, it was Harris, and Holly Harris is a clinical therapist. And if you look at her work history, Judge, she works with the Department of Corrections. She was an adult probation therapist for monitoring in the Saginaw Regional Correctional Facility for male inmates. She was on the treatment team for Saginaw County. She provided training for correctional officers. She was the jail liaison for Bay City Inmate Behavioral Health, where she dealt with substance abuse and jail diversion. And I think she's got a lot of credibility in regard to diagnosing male inmates in regards to what's going on. Recommendations for the court. What we have here is an individual with major depression disorder. He's obsessive compulsive disorder with PTSD. On top of that, he's got intellectual development disorder as well. None of these things have ever been addressed by any court, probation, or even through the Michigan Department of Corrections. That's not to say that punishment should not also be a component of this. Obviously, there is punishment that goes along with it. My client's been incarcerated for some time without getting any time due to the fact that he is on parole, still there. My recommendation is, let's see what we can do given this new diagnosis, and just do a local jail sentence followed by a lengthy probation where we get him the community mental health and try to see if therapy along with medication can aid in sort of stopping this cycle that's been plaguing my client for years. And he's done. He's tired of going through this cycle, and he's at a breaking point mentally, physically, everything in regard to what's going on in his life. What it boils down to is these cabins inside of these semi trucks is the last place my client felt safe from trauma when he was a young man, and that was when his dad was a truck driver, and my client was in the cab of the truck with his dad. This was before he was dealt with physical abuse throughout his childhood, and that's kind of where he reverts back to when he's dealing with levels of stress in his daily life. So it's kind of like his safe clubhouse. It's a self-diagnosis of impulse to steal these trucks. He doesn't get a rush from it. When he's in these trucks, it's a relief, it's a breath, it's finally the anxiety subsides. And that's kind of what's going on that needs to be treated. So again, my request is we do local time, followed up by community mental health, and we always have the ability, if he's violating on probation, if he's not going through with the mental health treatment, this court always has the option to still send him to prison on a probation violation. It's not taking it off the table, but it's taking into consideration the diagnoses we have and seeing what we do.
Thank you. Mr. Davis, anything you wanted to say today?
No, like you said, I agree with that. You know, if I get some kind of help, I'd appreciate it. I really would. You know, if it's medication, treatment, whatever, I'll take it. And I agree with him, everything he's saying. It's everything, you know, like you said, I felt safe in a cab or truck because my dad was a truck driver. You know, it's like, I'm done with this now. It's like, I need help. I need treatment. I need something. Me going back to prison, it's not going to be no good. It ain't going to help me. I'm just asking you if you can help me with this, please.
I read through the report, like I said, so I'm familiar with what happened in the circumstance as well as your background, Mr. Davis. I did read through the mental health assessment that was prepared. So I'm familiar with the information in that as well. And so looking at things, you know, as a whole, number one, I'm satisfied. I agree with Mr. Faber in terms of the individual's qualifications. I don't think there's any question about that. I think it's, even without that assessment, looking at your record and the types of crimes that you commit, I think it's reasonable to assume that there is an underlying some mental health diagnosis there. And that's brought out through that report. I think there's some question based on what I read in the report as to the accuracy of some of the information that you provided to the assessor. But even if we set that aside, I think there's clearly some mental health issues here at play. So I can accept that, and I agree with you and your attorney that I think that's established. The question is, how do we deal with it? You know, one of the options would be to keep you here locally with a 10-month sentence and put you on probation. The problem with that is, in order for somebody with the kind of record that you have, who hasn't had any real treatment prior to this, you're going to need significant supports present to make that successful. And you don't have any ties to Gaylord, you don't have any family here, you don't have any connections to this community. So if you're released on probation, my concern is we're going to be setting you up for failure. You're going to have no underlying support to that. So I don't know that that's a better option for you than the Department of Corrections in terms of getting help for what you need. Because without that underlying support system, you know, if you were a lifelong resident, you had all kinds of family and friends here who could help you and support you along that way once you were released from jail and on probation, I think there might be more of an argument for that. But without that, I don't see that being any more successful than you've been on your own, because you're just going to be on your own, really, again, with some supervision from probation. But that's not in and of itself going to solve the kind of problem that I think that you have. Aside from that, given your past record, given the status that you were on, given that you were only released for a short period of time before you immediately reoffended, I think all of that lends itself to a sentence in the Department of Corrections. And I think that's appropriate for the reasons I've stated. So the court is going to sentence you to the Michigan Department of Corrections for a period of 24 months to 7 years because of your parole status. You do not have any jail credit. The court is going to order restitution in the amount of $5,000. It's payable to the Otsego County Clerk to be dispersed to Smith Equipment Rental. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request the court appointed attorney to help you with any appeal.
Okay.
Yes.
For housekeeping purposes, the court said 7 years. This is a half to 5 years, that's 7.5 years.
Sorry, I was looking at the PSI. Then yes, it would be 7.5 years.
Thank you, Judge.
Favor, as Mr. Davis account received appellate rates.
He has his initial and top copy has been returned.
That's the estate this time, Mr. Davis. This way. I'll try. Is Ms. Rogers present?
I am.
Okay. Ms. Rogers, can you come up to the podium, please? On the record, is People versus Michelle Rogers. This is file number 256805. The record should reflect Ms. Rogers is present here in the courtroom today. If I could have counsel with your appearance.
Jonathan
Daver on behalf of Ms. Rogers.
Mr. Baber, can you tell me the status of this file today?
Yes, Your Honor. A plea offer has been extended to Ms. Rogers. She's wanting to accept that plea offer for today. They have placed the offer on record. Please. They would be pleading to count 1 with possession of methamphetamine. In exchange, the people would be dismissing count 2 as well as the habitual drug offense notice. In addition, they would not authorize on file 2442101157. Finally, Your Honor, there is a recommendation from the people in regards to this case for no upfront jail as a recommendation of sentencing. And I can provide the great copy of the offer.
Thank you. Mr. Rolla, is that a correct statement?
Yeah, I believe that was extended by Mr. Booker from our office, and that's a copy that was provided to me today.
Okay. Ms. Rogers, have you had an adequate opportunity to talk to Mr. Baber about
I
this?
have.
Is that how you wanted to proceed?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank
Judge,
you.
excuse me for a moment, but could Mr. Weaver and I approach for a moment?
Yep. Oh, sorry.
I think, Judge.
Ms. Rogers, you understand that by pleading guilty to count 1, which is possession of methamphetamine, that carries with it the maximum possible penalty of up to 10 years or a $15,000 fine.
I do.
Are you currently on any kind of probation or parole?
I'm not.
Was Ms. Rogers on bond or anything when this offense occurred? I know that there's that other file out there.
No, she was not. Just the first in time file.
Okay, so there's no potential consecutive sentencing sanctions.
No.
So Ms. Rogers, with that maximum possible penalty in mind, what is your plea for that charge?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand that you have all those rights?
I do.
And you understand that you're giving up and waiving those rights by pleading guilty?
I do.
Also, the only way that you can appeal this plea today is by leave to the Court of Appeals. That means you don't have an automatic right to appeal it. You have to ask them to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty?
Yes.
The information I have indicates this happened back on August 5th of 2024. Is that the correct day?
Yes.
On that day, were you here in, Otsego County?
Yes.
I'm in 3 different counties, so all in this week, so I gotta make sure I know where I'm at. So you were here in Otsego County on that day?
Yes.
And did you have possession of some methamphetamine?
I did.
Did you know that that's what that was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Baker? Satisfied. Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Baker?
No.
Mr. Rolla, are the people satisfied that the court has complied with statute and court law in the taking of this plea?
Yes, Judge.
Mr. Baker?
Yes, Judge.
Mr. Rogers, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. You're going to meet with Mr. DeLeo before you leave here today to set up a pre-sentence interview. And then it's important that you stay in touch with Mr. Baber between now and that sentencing.
All right.
Okay. Mr. Rolla, anything further on this file?
Not in this case, thank you.
Mr. Baker?
No, Judge, thank you.
Thank you.
Your next hearing set for 2:30, so we'll be in recess until that time.
All rise.
Okay, Mr. Daniel, are you able to hear me okay?
Yes, I can, Your Honor.
Okay, we'll go on the record in People versus Frederick Hess, file number 226346. The record should reflect Mr. Daniels present on behalf of Mr. Hess by Zoom. We have Mr. Rolla present here in the courtroom today. This had previously been scheduled for a trial. On the eve of trial, the court received notification from Mr. Hess' counsel that Mr. Hess had been arrested in a different jurisdiction on additional charges. I addressed that with both Mr. Jockins, I believe, and Mr. Rolla off the record on a Zoom conference. We all agreed, correct me if I'm wrong, Mr. Rolla, to adjourn the trial in light of Mr. Hess's situation at that time. So then we set this for a status conference here today. So Mr. Daniel, can you tell me what Mr. Hess' status is, where we're at from the defense standpoint?
Yes, Your Honor. I was advised that Mr. Hess had as a result of his new charges that arose in Tuscola County, he had a preliminary examination scheduled and he failed to appear. And currently the whereabouts of Mr. Hess are unknown.
Actually, Judge, I do have some additional information in that regard as well.
Okay,
Our office was contacted by Lieutenant Tim Harrison, Harrison, Bayonet, it's Bay County Drug Enforcement Team. And that's where the Tuscola charges came out of. Mr. Hess failed to appear there in their county on March 5th and is now believed to be in the state of Louisiana, where he's been supposedly since October, since it's like for some time anyway. I can't tell exactly what the date is on this. In any case, he's apparently in Louisiana. And I was told that if a bench warrant is issued, quote, to Lieutenant, please advise him because he would be happy to, if the extradition is approved, to personally go down and bring the defendant back to the state of Michigan. End of quote.
all right, based on the information from both counsel and just for the record, Mr. Hess is not present here in the courtroom today or by Zoom, although the hearing is set for 2:30 and it's now 2:40. I think it's wholly appropriate to issue a bench warrant for Mr. Hess' arrest. The court will order, to the extent he's on bond in this file, his bond to be revoked. Once he's arrested, if he's lodged here, the court will order that he be lodged without bond, and we'll set it for hearing for the first available date after he's brought into custody. Mr. Rolla, anything further on?
Just for perhaps housekeeping purposes, the bond situation, as I understand it, though, would not allow for extradition. So for our office to do, we probably have to issue new extradition charges, which our office may in fact do. That way somebody can actually go and bring them back to the scene.
So I'm revoking bond today.
Oh, okay,
So I don't know
all
if that makes a difference to you.
I don't know, I'm gonna have to check, Judge,
Okay.
but it requires a new felony charge. It can't be one that he's already been arraigned on. So that's the issue. I think bond probably would not allow extradition, but if we can get verification of where he is in Louisiana, then my officer would know. And I say this for the benefit of the defense counsel, since they're here. We would probably be looking at absconding charges, so that would give us the authority to bring him back to Louisiana.
Okay.
Thank you, Your Honor.
All right, thank you. Mr. Daniel, anything further from your side today?
No, Your Honor.
Okay, thank you. You're free to disconnect at this time.
All right, thank you.
And, We're on the record in People versus Garrett P. This is file number 246773. The record should reflect that Mr. Key is present here in the courtroom today. I'd like to have counsel put your appearances on.
The record, Your Honor, Michael, on behalf of the people.
Brian Klein, on behalf of Garrett Key.
All right. This is the date and time set for a sentencing hearing in this matter. Just so the council's aware, and Mr. Key, I did receive a letter from Caitlin Sullivan. I had a chance to review that prior to the hearing today. It was submitted on behalf of Mr. Key. Mr. Clayune, or first of all, Mr. Key, did you have a chance to go through the pre-sentence report and speak to Mr. Clayune about that?
Just know, Your Honor, I did talk to Mr. Rolla. I wasn't even aware that Mr. Key was back in Otsego County until yesterday. I talked to him on the phone. I haven't really had an adequate opportunity to discuss this pre-sentence investigation report. I'm here, and I did tell Mr. Rolla, I'd like to be a little more thorough in my pre-sentence investigation reports than 5 minutes before court.
Okay.
I'm asking the court for adjournment, a brief adjournment. Mr. Key obviously remains in jail. I'll come back over here. I would just like a little more time. I don't even though the PSI was mailed to him, I don't even know if he had a chance to read it. I think with the recommended sentence, a brief delay just for that purpose to make sure he adequately understands his PSI and his guidelines for his sentencing recommendations. I would ask for a brief adjournment. I don't need much time, a week even would be fine.
Mr. Rolla?
If people have any objection to that, Judge, I would also note that because of Mr. Key's absent himself from the court, the PSI on as to OB 19 has to be added 10 points as well for scoring purposes. So that's something else Mr. Clear would have to go over with his client. I hadn't filed a motion to that effect yet anyway. But so in that regard, we don't have it, especially in light of the fact that he's going to be in custody, so he can't go anywhere. So the people have no objection to the court granting an adjournment to allow the defense counsel to speak to his client more thoroughly before sentencing. But again, we don't want to have it unnecessarily continue too long of a time period.
All right, I think there's an adequate basis to allow for the adjournment. In this case, the court will grant the request. We'll reset it for sentencing. I can't give you a date today, Mr. Clayton, but our office will renotice it. You'll be provided that along with Mr. Key.
I appreciate that. Thank you, sir.
All right, thank you.
Mr. Key.
Yep. Ms. Walsh, are you able to hear me okay?
Yes, I can hear you.
All right, we'll go on the record in People versus Jennifer Freeman. This is file number 226336. We have Ms. Walsh present on behalf of Ms. Freeman. By Zoom video, Mr. Rolla is present here in the courtroom. Ms. Walsh, is Ms. Freeman still incarcerated?
Yes, I did check the MDOC website and she is incarcerated, but I would waive her presence for purpose of this motion only.
Okay, very good then. Thank you. I did have a chance to review your motion prior to the hearing today. Is there anything that you wanted to state for the record and support that motion by way of oral argument?
Well, I think the arguments are laid out in the motion. I would just add that the main underlying purpose of the motion is to help Ms. Freeman get back on her feet. She has very serious drug addiction issues. And so any kind of a payment program would help her in that endeavor. And so we would just ask that an installment plan be entered and that the $174 late fee that was already imposed be stricken from the judgment.
Thank you. Mr. Rolla, do people take any position?
Just, of course, well aware the court has the authority to waive the late fee. Again, it's discretionary, but we don't take any position on that. As to a if you will, payment plan. That actually should have been brought as a motion to amend sentence or amend probation, but again, the court can decide to do that if they want. However, there needs to be some indication that she's actually going to follow that rule. I don't know what her circumstances are since she's a transfer. Thank you, Judge.
All right, thank you. Having reviewed the motion, the court does have the authority to waive the late fee, as well as to make provisions for a defendant to, for different ways for a defendant to make payments towards outstanding fines and costs. I agree with the relief requested. Ms. Walsh, the court will grant the motion to the extent it's requesting to waive the late fee. In terms of the installment payment, the court will grant that request as well. I would just say that that's something that Ms. Freeman's likely going to have to address with the clerk's office here in Otsego County once she is released and is on parole. But if you can prepare an order reflecting the ruling of the court today, assuming that she'll get a copy of that order, she could bring that to the clerk's office, but I want to make sure that, you know, once she starts making payments, that the clerk's office is fully aware, even though they'll obviously get a copy of the order for the file as well, but sometimes communications get crossed. So.
And you're
Okay, well,
go ahead, counsel.
thank you very much. I will definitely get that order prepared, and I will make sure that Ms. Freeman gets a copy of it, and that I stress to her to bring that to the court and to make sure there are no miscommunications and that everything is paid in a timely manner.
And Judge, for housekeeping purposes, if it'll ease matters, if Ms. Walsh wants to email a copy of the proposed order to our office, then I can approve it and allow her. I don't know how she's submitting it, but that way I can have it so that way there's no problem with getting it to the court.
Okay, could I have that email address to send that order?
Yes, it's M as for Michael, Rolla, R-O-L-A, just like Cola except with an R, at Otsego, O-T-S-E-G-O, county, C-O-U-N-T-Y, mi.gov. Rolla at Otsego County, mi.gov.
Okay, thank you. I will do that, and we'll take it from here. Thank you very much.
Okay, thank you. That's all in this file, and Ms. Walsh, you're free to disconnect.
Thank you.
Okay, our next hearing is set for 3:30, sentencing hearing, Mr. Matthew, so we'll be in recess. On the record in People versus Matthew, file number 195787 and file number 205947. If I could have counsel put your appearances on.
Thank you, Your Honor, for the record, my Collins application.
Good afternoon, Your Honor. Fabiola Delgado on behalf of the defendant.
Thank you. This is the date and time set for sentencing. File number 579-19597. Matthew, you had an opportunity to go through the report and talk to Ms. Belgara about that? Yeah, sure. Okay. Ms. Belgara, are there any additions, deletions, or corrections that need to be made to the report?
Your Honor, yes. In particular, when it comes to the guideline calculations.
Okay. Which variables are you changing? Well, before we get to that, are there any changes to the body of the report?
No, Your Honor.
Which variables are you changing?
Yes. So across the board for all 4 counts, challenging PRV 7. 7, which allows for enhancement based on subsequent convictions, on all 4 counts has the maximum, which is 20 points enhanced. There have been no subsequent convictions, and if we're using the offenses themselves to count as the basis for enhancement, then at least one of them would have to not have the enhancement for subsequent convictions, considering it would have been the last act.
Are there other variables that you're challenging as well?
Yes, Your Honor.
Okay. Give me a list of all the variables.
Oh, okay. That would be PRV 7, OV 3, OV 4, and OV 10.
So the court has a policy, and may not have been aware, I know you don't normally practice in this court, but where when a party's challenging variables or scoring, file a written brief prior to sentencing, so the prosecutor has an opportunity to respond and so forth. Mr. Rolla, given the number of challenges, do you want to proceed on the record today? I think you would have the right to ask for an adjournment in order to address the challenges. So I'm going to ask you how you want to proceed.
Well, Judge, I already know my responses as to PRV 7. It's not just subsequent.
But I don't want to get into
I
argument first.
understand that.
I don't want to argue some of it.
I appreciate it. The victims are here, and I don't want to have to make them come back again.
Okay.
I will be prepared to argue today, Judge, with the court's permission, of course.
Yeah, absolutely. All right. So go ahead. Then, Ms. Belgara, did you have anything else you wanted to argue with regard to PRV 7? And actually, I'm going to need to get a copy of the sentencing. Hold on 1 second. We don't have to go off the record or anything. I'm just going to run back.
I
and
only
change
have
it.
this one. It's a short one.
So let's. Right, so PRV 7 is subsequent or concurrent felony convictions. We're currently scored at 20 points, which is 2 or more subsequent or concurrent felony convictions. Mr. Rolla, what's your argument in response to Ms. Belgara's?
Judge, the defendant was convicted of multiple counts. Each one is concurrent and or subsequent. They don't have to be subsequent to the offense. They can be concurrent. And they're one or the other. Obviously, if there's at least 4 counts, then there's at least 3 that are concurrent or subsequent. Scoring is correct.
Okay, Ms. Belgara, any response to that?
No further comments.
All right, I do believe Mr. Roll is correct. I think PRV 7 is correctly scored based on the fact that we have 4 convictions here. So as to each sentencing offense, there are 3 concurrent felony convictions. So if the court will deny the challenge to PRV 7, that remains scored at 20. The next challenge was to OB 3. physical injury to a victim that's currently scored at 10 points, which is bodily injury requiring medical treatment occurred to a victim. Your argument on that one, Ms. Gardner?
Your Honor, my argument on this one is that instead of being scored at 10, it should have been scored at 5. Bodily injury not requiring medical treatment occurring to a victim. Looking at MCL 77.33, it also, it's not just, it's necessity of treatment as well. Now, while there was testimony at trial that there was a physical injury and that it was treated, there was no testimony on the record that the injury itself necessitated or required treatment. Furthermore, there was testimony at trial that such an injury could have occurred from consensual sex. That with all those factored together, I believe that scoring of 5 would be more accurate than 10, considering necessity and requirement.
Judge, the testimony in this particular case is that the victim suffered a half-inch tear to her labia minora. That the nurse who testified to that indicated, as the jury found, this was not consensual sex as to any of the counts. Further, even were that not the case, as the medical information indicated, as the victim testified, she was given, and as is reflected in the PSI, she was given prophylactic treatment too, which under case law allows scoring as considered medical treatment for the purposes of scoring this offense variable. It's scored correctly. The objection should be denied.
Anything further? Ms. Gardner?
Yes, with regard to the testimony regarding the injury at trial, the nurse's specific testimony was also that such an injury could occur from consensual sex. Now, obviously, the trial, the jury found Mr. Matthew guilty on all 4 counts. There is, however, both admissions by the victim in this matter as well as Mr. Matthew that there's at least started as a consensual sexual interaction. So where the injury source, nonetheless, I would argue is irrelevant, but I would posture that because it's not necessary or required treatment for such an injury that it should be scored at 5 instead of 10.
In this case, the court has testimony from the jury trial to rely on, sworn testimony in terms of factual basis in order to support the scoring of a particular offense variable. The court has to find that there is sufficient evidence by preponderance of the evidence standard. The court is familiar with the trial testimony. I presided over the trial. There was testimony that there was an actual physical injury to the victim in this case. I don't find that whether or not the encounter was consensual or whether such an injury could result from consensual sexual activity to be the crucial factor here. I think that the injury itself and the degree of injury and whether it required medical treatment, regardless of whether the victim sought medical treatment for it, is the operative factor. In this case, there was testimony from the witness and documentary evidence introduced to show that there was an actual injury. The nurse witness testified that she did prescribe medications related to that injury. And so the court finds, based on that, by a preponderance of the evidence, there's support to find that there was an injury that required medical treatment. And that medical treatment in the form of medications was actually administered to the victim. So the court will deny that challenge, and OB3 will remain scored at 10. The next one challenges to OB4, which is psychological injury to a victim.
Yes, Your Honor.
Your challenges.
So it's serious psychological injury requiring professional treatment. While I believe there was testimony from Ms. Stiles that she has sought treatment, there wasn't any testimony from a psych professional to talk about the degree of psychological injury and whether treatment was necessitated and what kind of treatment was needed.
With respect, Ms. Stiles testified not only that she sought treatment, but that she actually got it for quite some period of time. It's a situation where, again, this offense variable is properly scored.
Do you know whether Ms. Stiles is going to make a statement to the court?
Judge, she has indicated that she has her written statement. As far as advising the court on the extent of that treatment, I think if that's what the court's looking for, I don't know if she wants to do that or not. She's available to do so, Judge. And the court may want to hold off on the challenge until after they hear what she has to say.
All right, I'm gonna reserve ruling on OB4 until Ms. Stiles makes a statement. If she elects not to make a statement, then the court will rule on it based on the evidence of record. OB10, then,
Your Honor, we posit that OB10 should be scored at 0. There was no testimony that Ms. Stiles during the incident was asleep or unconscious. There was different testimony regarding levels of drinking, whether marijuana was involved or not. Though Ms. Stiles testified to having a memory of the incident. There's no other indications that she wasn't conscious or there mentally. And then size alone, I believe, in consideration of other factors that go to vulnerability, wouldn't lean towards bumping this all the way up to 5 points, considering that the size difference is not so extreme as to implicate physical exploitation. Restraint.
Judge, I believe Ms. Stiles, and again, I apologize for the language around it, but it's not just unconscious, it's also immobilized for this scoring of this variable. And Ms. Stiles repeatedly, unfortunately, had to testify about the defendant holding her down or holding her legs up in the air or holding her and pinning her down and putting his hands behind her head and pushing her down when he's bitingly and holding her. This is properly scored under this offense variable. I think the objection should be denied.
right, again, relying on testimony at trial, particularly of Ms. Stiles, I think without pointing to any particular statement that she may have testified to, but her testimony in general about the encounter was essentially that Mr. Mathey used his size and his strength to overcome her to accomplish the sexual act in various ways against her will. And I find that her testimony by preponderance of the evidence would support a scoring of 5 points under OB10 in that Mr. Mathey used that difference in size and strength to accomplish the assault in this case. So the court will deny the challenges of OB10 as well. Other than OB4, are there any other challenges, Ms. Belterra?
No, Your Honor.
Mr. Rolla, do people have any additions, deletions, or corrections?
No, Your Honor.
People have any challenges to the scoring of the guidelines? And did you want to confirm with Ms. Stiles whether or not she wanted to make a statement or address the issue of her psychological?
And Judge, how about she sits where I'm at right now at the court?
Whatever is most comfortable for Ms. Stiles.
That she will address the counseling that she not only sought, but in fact actually participated in, and what caused her to have to get that counseling.
All right, and just for the record, you're Ashley Stiles,
Yes,
the victim in this case, is that correct?
Yes, sir. I went to Old Town Psychological Services here in Gaylord, on and off for a number of years. My counselor name there was Cooper. The reasoning behind having to go is because of everything that happened back in June of 2019.
What would you suffer as a result of caution? Question.
Depression, PTSD. I was nightmares left and right. I didn't want to leave my house.
All right, thank you.
Thank you, Ms. Stiles.
In light of Ms. Stiles' statements here for the record, the court finds that, again, under a preponderance standard, that there is a sufficient basis for the scoring of OB4 at 10 points, and the court will deny that challenge. I did have a chance to review Ms. Stiles' statement that she provided in writing prior to the hearing today. Mr. Bola, do you have any other victims that wish to address the court?
I do not touch it.
Thing on behalf of the people for allegation.
Yes, I do, Your Honor. Thank you. This defendant, the fact that this isn't even his first sexual assault conviction. He has a prior as indicated assault with intent for penetration. Clearly is a predator, a sexual predator. He committed these assaults, which the defendant's PSI describes as defendant's actions of June 17, 2019 as quote, particularly brutal, end of quote, which in light of the defendant's slapping, punching, biting, and choking the victim prior to forcibly raping her in various abominable ways, causing a half-inch tear in her labia minor, is perhaps in the prosecution's position quite the understatement. In addition to the defendant's prior October 29, 2004 conviction for assault with intent to commit sexual penetration, that's item 1 of 4 of his adult history, the people submit that it's worth also noting defendant's prior April 8, 2008 conviction for domestic violence. Based upon his priors and his heinous acts, which he's currently now being sentenced before this court, there can be no question that unless he's incarcerated, the defendant will continue to pose continuous threat to women in society. As indicated by the Department of Probation and Parole pursuant to MCL 750.520B3, this court has the discretion to sentence the defendant as to count 1 consecutively as to constitute justice for this victim in this case is long overdue, and doing so would hopefully restore a modicum of justice for Ms. Stiles. As this court can sentence the defendant in that fashion, the court, the people would ask the defendant be sentenced at or near the top end of the guidelines, which for count 1 are 126 to 262 months to life. Thank you, Your Honor.
Ms. Belgara, anything on behalf of Mr. Matthew?
Yes, Your Honor. First and foremost, and again, I apologize for not being familiar with the customs of the court. I do have 3 statements in support of Mr. Matthew provided by people who are close to him. If I could provide a copy to both the prosecution as well as the court.
Yes, if you want to hand my copy to the
Absolutely.
And we have no objection to that, Judge.
just take a moment to read these. I did have a chance to review those. Ms. Belgara, did you want to have those attached to the pre-sentence report?
Yes, Your Honor.
Okay. Anything else on behalf of Mr. Matthew for allocation today?
The 3 statements that I've provided are statements from his mother, one of his close friends, and a woman who's known Mr. Matthew for 10 years. These 3 women have shared today with this court that Mr. Matthew is someone that they personally feel safe with, that he's someone who can contribute positively to the community and has contributed positively to their lives. Miss Matthew, Miss Veronica Matthew, Jonathan's mother, talks about some of the difficulties that he had growing up and the difficulties that have led him here and what he's done to overcome some of the stuff that have happened along the way of his growth, because I don't think the pre-sentence report fully captures who Mr. Matthew is. Miss Lacey Keeklum shares her personal experience, testified in this court, and has known Mr. Matthew despite, you know, being people that were almost in a romantic relationship, right now just friends who likely have had disputes amongst themselves, is someone that ultimately finds that Mr. Matthew is someone that's safe, that's someone that can add to the value to the community. Ms. Lucas relies on him just beyond social as someone who can help her when it comes to household items, taking care of her loved ones as well as his own. Furthermore, this court heard testimony from Miss Angela Lomax, Mr. Matthew's ex-wife, who herself, you know, expressed support for Mr. Matthew despite the allegations, having, you know, children in common with Mr. Matthew and expressing that she didn't buy into this image of Mr. Matthew as someone who can't be redeemed, to someone who's permanently set on a path for wrongdoing. Mr. Matthew, over the last few years, has lost contact with his children. A long extended prison sentence, especially one with consecutive sentences, would lead to further distance for his family, further impact on those children, and significant roadblock to being able to be a family. Mr. Matthew hasn't spoken to his children, I believe, since roughly 2019. Looking at a couple of years of prison sentence, we're talking about not having a relationship with children for decades. Mr. Matthew is capable of following court rule, despite you know, some of the comments made by the prosecution, its allocution. Mr. Matthew, this court trusted out on bond despite the allegations he was facing, and there was no issue with that. He was allowed to work. He had gainful employment in several places. There were difficulties in finding employment given some of these prior factors mentioned by the prosecution, but did everything he could despite facing something as serious as what he's faced at trial, what he's facing today, and still contribute. Mr. Matthew, I believe, is going to give a statement here today as well. This court is aware of the testimony he gave. He, you know, took the stand, testified to what he could recall, to his recollection of what occurred with Ms. Stiles. He has faced the music for all intents and purposes, and I ask that the court sentence at minimum and move forward with concurrent sentences, given that concurrent sentences is kind of the standard for Michigan. While there is discretion to go for consecutive, it's not just a jump that should be taken lightly. For those reasons, I ask that the court sentence at minimum and consider keeping concurrent sentences.
Mr. Matthew, was there anything you wanted to say?
Yeah, I do have a statement for that. Sorry. So, Your Honor, it's genuinely heartbreaking that Ashley Stiles and I experienced the falling out we did in 2019, which has resulted in the difficult circumstances we find ourselves in today. While our relationship started out as a consensual one, I feel that we were also developing a meaningful friendship at that time. Both of us were struggling with our challenges, and it seemed we instinctively turned to each other for comfort and sense of connection. After our last intimate encounter, our communication felt light and easy, filled with humor and flirtation. I sensed no sign of distress or anger from Ashley. However, when I entered into a new relationship, I was blindsided by the feelings of confusion, fear, hurt, and betrayal that followed, not from the new partner, but from someone I started to care about deeply, Ashley. The fact that she filed a complaint against me was shocking. As weeks went by, I struggled with the weight of these allegations. I was surprised when Ashley later reached out, trying to withdraw her complaint and inviting my children, my ex-wife, and myself to her wedding. I took this as a sign that she wanted to rebuild our friendship, and I genuinely wanted that too. Unfortunately, circumstances didn't allow that to happen. I truly valued the companionship and support that Ashley provided me, especially in the early stages of our friendship. I want to emphasize that I'm not a criminal. I've never intended to cause harm to anybody. I don't destroy or property or commit malicious or or nefarious acts. I followed Ashley's lead during our encounters, and in retrospect, I realized we should have communicated more openly about our feelings and desires. I deeply regret any pain my actions may have caused Ashley. This lack of communication has led to heartache for both of us and for those around us. I'm sincerely remorseful for the turmoil this has caused everyone involved, including Ashley, myself, our families, and friends. I wish things had turned out differently, and I'm truly sorry for the hurt we've all experienced. Your Honor, as you consider the length of my sentencing, I ask that you keep in mind that I have family members who depend on me, especially my children, both of which I would love to, maintain and rekindle some sort of fathership to. My son he's a teenager now. He's faced significant medical challenges and academic difficulties throughout his life. And the last 5 years have had a profound effect on him in ways that are difficult for me to understand. I also have an adult daughter who is more capable of coping, yet still seeks my support in her own way. In addition to my children, my parents are aging, which will soon reach a stage where they heavily rely on me. While I'm at an age where the possibility of regaining my freedom is within reach, my parents do not share the same outlook. They don't have the luxury of time. They'll soon need assistance in navigating the remaining years, and I fear I might miss the opportunity to be there for them when they need me most. Potentially missing their final days. Time's a precious commodity that once lost, we cannot be reclaimed. The people we love, once gone, can't be replaced. I humbly ask you for your compassion, not just for my own sake, but for the sake of my family who depends on me. Thank you.
Great, thank you. Mr. Matthew, I did read through the pre-sentence report, so I'm familiar with all the information contained within that. As you're aware, I presided over the trial. I heard all the evidence and testimony, including your testimony and the witnesses on your behalf. I take all of that information into consideration along with what both the lawyers had to say here and of course what Ms. Stiles had to say. So I'm well familiar with the facts of this case and your background and your history. The first thing I would point out, Ms. Stiles, I think it was very courageous of you to come forward to report this in the first place. Your letter, I thought expressed very well how difficult it is after all this time to have to come and testify at a trial, given the amount of time that had passed and how that has inhibited your ability to move on from this. But I do think that your actions both at the beginning and sticking through this and testifying at the trial sets a good example for other victims, and hopefully provides a degree of courage to them. If they see people like you doing that, they feel like they can come forward and report crimes like this. So I think that has to be acknowledged, because that couldn't have been an easy thing for you to do. And again, I think it sets a good example for other people who are victims of this type of crime. I don't think there's a lot that needs to be said about the facts of this case and the circumstances. We had a trial where that was all brought out, and I don't think repeating that is going to add anything to the sentencing. I think the testimony, the physical evidence all speaks for itself, that this was a forceful, violent encounter that wasn't consensual. I have full confidence in the jury's verdict in this case, and it's based on evidence and a rational, common sense view of that evidence. I think there are also indications, Mr. Matthew, that have been pointed out by the prosecutor and evident in your history, that you have some issues controlling your sexual urges. You have one prior conviction. There was testimony regarding separate series of events involving similar crimes. The reason why the legislature, through statute, allows other kind of evidence of those acts to come in is because that particular type of crime is something that generally isn't a one-off kind of a thing. It's something that's a pattern of behavior that's driven by something within a person that doesn't allow them to control themselves and allows them to continue to commit crimes like this. And I'm confident based on your history that this wasn't a one-time thing. And I say that because that's important in terms of the court's consideration of what an appropriate sentence is in this case, because part of my job in sentencing is not only to punish you and to provide a deterrent so that other people don't engage in this kind of conduct, there's also the protection of the community so that you're in a place where you're not, you don't have access to individuals in order to victimize them as well. For those reasons, I do think the sentence to the Department of Corrections is appropriate. It's within the guidelines. The Department of Corrections sanctions recognize the seriousness of the charges in this case and the behavior, the wrongfulness of your behavior, the amount of damage that it's done to Ms. Stiles in this case, other people in other circumstances. The court finds that the sentence at the high end of the guidelines is appropriate. I find that consecutive sentencing sanctions is the most serious type of sanction that a court can provide in the state of Michigan. I think that it has to be reserved for only the most egregious cases. Using consecutive sentencing sanctions in anything other than the absolute most egregious cases lessens the importance and the significance of it. There's no question that your behavior in this case is wrongful and deserves serious punishment. You do not find that it rises to the level that would justify consecutive sentencing sanction. However, I do find that it does rise to the level of penalty at the top end of the guidelines. So as to count one, which is the criminal sexual conduct first degree involving personal injury, or will sentence you to Michigan Department of Corrections for a period of 262 months to 40 years. You do have credit for 887 days served. As to count two, criminal sexual conduct third degree force or coercion, court sentences you to 181 months to 22 years. As to count three, assault with intent to do great bodily harm less than murder, court sentences you to 47 months to 15 years at the Michigan Department of Corrections. As to count four, also 47 months to 15 years in the Michigan Department of Corrections. Those sentences to be served concurrently, again, with all sentences to include 887 days of jail credit. Court is also required to impose the crime victim's assessment of $130, court costs of $325, $272 state cost, and because of the nature of the convictions by statute, the court is required to order lifetime electronic monitoring. You do have the ability to seek an appeal of these sentences. Ms. Delgara, I typically have defense counsel have knowledge receipt of the appellate rights. Have you done that?
I haven't been able to, haven't signed it, but I have a form.
Okay, if you can have Mr. Matthew acknowledge receipt of those before he leaves right now. Well, any further we need to address the record. So Matthew, you are remanded to the custody of the state.
Jury status conference on the next
Oh,
case.
with regard to the jury status conference, I'm gonna reset that for next month, given the sentences in this case. I want counsel to have an opportunity to speak.
Very good.
With your
Thank you.
victim in the
That was
other
gonna be my
cases.
request.
Your Honor, if possible for that, the next status conference, would it be possible to preview Zoom?
Yes.
Thank you.
That concludes the court's afternoon docket.